Good day, Crime Talk aficionados. It is Sunday, which means this is the weekly recap of all the top stories located in one convenient location. Remember, this is the weekly recap of all the top stories for the week of January 27th, 2025. Enjoy, have a wonderful weekend, and remember, the Constitution matters.
All right, lawyer.
All right, ladies and gentlemen, if you joined us several weeks ago on a live program, we talked about how Luigi Manon has to win this case, okay? He's got a tough road. He's got a tough road ahead of him, but why are we going to let the facts get in the way of a good defense? That's what I always say, all right? It comes down to identification. Remember, in any criminal case, the prosecution must prove that it is, in fact, Luigi Manon that committed the crime, not someone that looked like him, not someone using his identity, but it was, in fact, him. And when we had that live program, I told you about a case. It was a homicide case back in Denver some 30 years ago, where 4 bank guards were killed by an allegedly retired police officer and ran off with the money. Anyway, that retired police officer was arrested. He has since passed away, and he passed away. But he was found not guilty at trial. And why did they do that? They did it based upon identification. Now, can you imagine how good the technology could be in this particular case in 2025? This case goes back years. And just so you're clear, it's a book called Murder in the Bank Vault. It's written by Walter Garash, who has since passed away. He was the lead attorney. He was an absolute legend. Here in Denver, is probably one of the greatest defense attorneys ever. So what did he do? Well, they had a general description of the man that came into the bank. That he had a fedora hat on and eyeglasses and a mustache. And I'll just show this, and Frank will probably put a better picture of it up. But look, those are the people in the disguise. This was 30 years ago, right? And then you see that the people in the book, Lee Iacocca, Marlon Brando, Robert Duvall, Jack Nicholson, under the disguise. Well, I have found the perfect person for that disguise, to put him in the picture to show that it could have been anybody. And look at this individual. That's right, actor Dave Franco. Look at this guy. Does he not look like Luigi Manon or what? He's apparently even getting asked about it, and apparently people have inquired whether, when the Luigi Manon movie comes about, whether he will be a part of it. Apparently there's nothing official, but look at him side by side. Could that be him? Put a mask on him. Yeah, pull that mask away. It's Mr. Franco, not Luigi. Reasonable doubt, ladies and gentlemen. Reasonable doubt. Mark my words, they're going to go ID. Anywhere, does it end here for the It Ends With Us lawsuit? That's right. Does it end in trial? A federal judge set a trial date in March of 2026 and moved an initial conference from mid-February to next week as the public feud between Blake Lively and her It Ends With Us co-star and director Justin Baldoni continued to grow and pick up speed. Anyway, this new and separate front in the series of the legal battle surrounding the film that became a surprise hit last summer. I've seen it. I actually thought it was really good. Now, the judge also moved an initial conference from mid-February to next week and told the lawyers to be prepared to address complaints about the pretrial publicity and the conduct of, some of the attorneys involved. The judge took the action after Lively's lawyers claimed in a filing on Monday that an attorney for Baldoni was trying to taint potential jurors over lawsuits the actors have filed against each other. Now, the lawyers allege that Baldoni's attorney was trying to wreck Lively's career and turn potential New York jurors against her by creating a website to release selected documents and communications between Lively and Baldoni. The lawyer said attorney Bryan Friedman, representing Mr. Baldoni, was engaging in extrajudicial campaigns to influence these proceedings and the public perception of legal filings to this court, and that there is already a serious risk that this misconduct is tainting the jury pool. The motion added, the endless stream of defamatory and extrajudicial media statements must end, Friedman said in the statement in response to Monday's assertion that the irony is not lost on anyone that Miss Lively is so petrified of the truth that she has moved to gag it. We will always respect the court. However, we will never be bullied by those suggesting we cannot defend our clients with pure, unedited facts, the lawyer noted. He continued and said, all we want is for people to see the actual text message that directly contradict her allegations, video footage that clearly shows there was no sexual harassment, and all the other powerful evidence that directly contradicts these false allegations. Now, in a letter to the judge Thursday, Baldoni's attorney, a guy named Kevin Fritz, accused Lively of a publicity campaign that left Baldoni and other defendants the objects of public scorn and contempt. Can you imagine such a thing, ladies and gentlemen, when you file litigation to say bad things about people? Anyway, he said actions had damaged those that she sued so that they were exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Miss Lively's scorched earth media campaign. In a separate filing in Hays County, Texas, a precursor to another potential lawsuit, Miss Lively asked for an order for a deposition from Jed Wallace, a crisis management specialist she alleges was behind much of the social media manipulation surrounding the film that turned public sentiments against her through posts on Reddit and TikTok. Now, Wallace and his Texas-based firm, Street Relations, were brought on as subcontractors by publicists working with Baldoni and his production company. He weaponized a digital army around the country, including New York and Los Angeles, to create, seed, manipulate, and advance disparaging content that appeared to be authentic on social media platforms and internet chat forums, the filings allege. Now, Wallace is identified in Lively's federal lawsuit, but he is not named as a defendant as of yet. Anyway, Miss Lively sued Baldoni, his production company, and others in New York in late December for sexual harassment and attacks on her reputation, and asked for an unspecified money damages to be awarded. Baldoni sued earlier this month, accusing Lively and her husband, Ryan Reynolds, of defamation and extortion, seeking roughly $400 million in damages. Probably what Ryan Reynolds is worth, or maybe he's close to a billionaire. I don't know. He's a funny guy, though. Anyway, the judge said Monday that he'll likely combine the lawsuits for trial. Anyway, It Ends With Us is an adaptation of Colleen Hoover's best-selling 26 novel that begins as a romance but takes a dark turn into domestic violence and was released back in August of last year, exceeding box office expectations with a $50 million debut. But the movie's release was apparently shrouded by speculation over discord between Lively and Baldoni. Lively came to fame through her 2005 film, The Sisterhood of the Traveling Pants, and bolstered her stardom on the TV series Gossip Girl from 2007 to 2012. And she has since starred in films including The Town and The Shallows. Baldoni starred in the TV comedy Jane the Virgin, 5 Feet Apart, and wrote Man Enough, a book pushing back against traditional notions of masculinity. It's going to get ugly, ladies and gentlemen. You thought the Johnny Depp trial was going to be a circus. Wait for this one. It's going to be good. I like the movie. I know the guy, Baldoni, was the actor and the director and whatever. Lively was good in it. But Ryan Reynolds is funny. I mean, if I got to pick sides, I got to go with Ryan Reynolds. I just think the guy's funny in Deadpool. But that's just kind of the humor that I like. I don't know what to tell you. I don't know much more about it other than that. But I like Ryan Reynolds. And he's married to Miss Lively. If you got to pick a team, I guess that's how we got to do it, right? Let me know what you think. Bryan Kohberger gets a win? Now, did he get his case thrown out? Did he get some evidence suppressed? Not yet, but he did get the judge to order the secret hearing released, at least the transcript anyway. I'll explain. So the judge overseeing the case against the man accused of 4 students that were murdered, Bryan Kohberger, has announced that he will release a redacted transcript from a closed-door hearing held last week, which he had initially barred the public and the media from attending. So the Ada County Judge Stephen Hippler told officials to hand over verbatim copies of the unredacted transcript from the sealed hearing on January 23rd to both the prosecution and the defense so that they can recommend proposed redactions. Now, both sides will have 14 days to identify portions of the transcript that should be redacted from public disclosure, providing a basis for the same. Now, thereafter, the court noted in the order, the court will release to the public a redacted transcript of the previously closed portion of the hearing. Now, remember, this is significant because the hearing regarding forensic investigative genetic genealogy, IgG, the evidence that was used to link Bryan Kohberger to these murders, that's what was discussed. Obviously, Kohberger's lawyers want all of that evidence thrown out. So we're going to get to find out why the prosecution doesn't want this released to the public. Very interesting indeed. So we brought you the hearings last week, but during a two-day public proceeding, following a closed hearing last week, the attorneys argued that the FBI violated Kohberger's Fourth Amendment protection against unreasonable searches and seizures. Now, the judge was somewhat skeptical and actually even said, I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy to that. The judge asked Ann Taylor, Kohberger's lead attorney, and Hippler appeared unreceptive to their argument that the IgG techniques violated Kohberger's constitutional rights and questioned whether the defendant even had standing to challenge the investigatory tactics that the FBI used. The judge noted it wasn't his DNA that was searched. At best, it was his ancestors. Ms. Taylor also argued that the FBI violated its own internal policy when checking IgG samples against a database. The judge asked prosecutors why he should allow the evidence to be introduced. The prosecution countered in their argument that there is no expectation of privacy in connection with public records and crime scene evidence. And the Idaho Deputy Attorney General stated to the court that the FBI's interim policy that Ms. Taylor questions does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities. So much of the IgG process has been sealed by the court, and the unredacted transcripts will give us a little more detail on how investigators pieced together the case in the weeks following the murder and tracked Bryan Kohberger to his house in Pennsylvania. Now, ahead of the hearing, the defense had asked the proceedings to be public, and a briefing on the matter was to be unsealed, but Hippler denied that request. Now, we will learn what steps the prosecution has taken and why they're fighting so hard to keep this from the defense and the public. News media organizations had filed requests for this hearing to be open, and ultimately the judge, I guess, somewhat conceded, but they argued it is the openness of the interested parties that seek to ensure so that they can play their vital role as surrogates for the public in providing an accurate and unbiased depiction of the upcoming criminal proceedings for which Idaho and its people are deeply concerned about, and people nationwide, to be quite frank. Anyway, Kohberger is scheduled for a trial later this year in regards to the home invasion murders of Madison Mogen, Kaylee Gonzalez, Zaina Carnoble, and Ethan Chapin. Now, remember that attack took place about 4 a.m. on November 13th of 2022, and all four were inside their off-campus house that they were renting. Kohberger was a PhD student studying criminology at Washington State University, just up the road in Pullman, Washington, which is about 10 miles away from the crime scene. Now, originally, the judge handling the case, Judge entered pleas on behalf of Mr. Kohberger at his arraignment back in 2023. And Kohberger's lawyers ultimately moved for the change of venue, and they got new judge on this case, Judge Hippler. Now, if Kohberger is convicted, he could face the death penalty, and the defense is still awaiting Judge Hippler's decision on whether to grant a Franks hearing in which they hope to have the warrants in the case thrown out. I wouldn't hold my breath on that. They're rarely granted and even more rarely successful. Interesting, but it is a win. Kohberger, there's some reason why the defense finally decided that they want all this information open to the public. Remember, it was defense that wanted it all sealed originally. Something has changed. What has changed? Well, there must be something that they think the public may find offensive as to how the prosecution used this particular information. I mean, think about this, ladies and gentlemen. You really don't have an expectation of privacy as to information that your ancestors gave to this organization to figure out their heredity, right? Particularly if you weren't involved in it. So I think that's why ultimately the judge will rule against the defense. But there must be something that the defense thinks is going to help them in the court of public opinion as to why they're doing this. And apparently the judges realized, well, there's apparently nothing here that's so offensive or outrageous that it needs to be released to the public. I'm of the opinion that this all should have been released to the public. All the briefings should have been released to the public, and all of the hearings should have been open to the public. I think that creates appellate issues when the judges start having closed proceedings and there's no basis for that. You can go into any courtroom across the country, and I don't care how heinous of the case it is, you as a member of the public can sit in there and watch all of those motions hearings. I don't understand why Idaho thinks they can do everything in private. It's absolutely disgusting in my opinion. Next on the docket, that's right, Rex Heuermann. That's right. Take a look. The pizza's amazing, but make sure you finish the crust. All right? His lawyers are arguing that the DNA analysis relied upon by the prosecutors is not widely accepted in the scientific community and therefore should be excluded from the trial. I agree if it's junk science. Anyway, the Long Island residents' defense team also wants to break out the case into multiple trials, which I totally agree. So since 2010, police have been investigating the deaths of at least 10 people, mostly female sex workers whose remains were discovered along an isolated highway not far from the Gilgo Beach on Long Island's South Shore, hence the name the Gilgo Beach murders. Anyway, Heuermann was arrested in 2023 and charged in the death of 3 of the victims between 2009 and 2010. Specifically, that was Melissa Bartholomé, Amber Lynn Costello, and Megan Waterman. Now, while he was in custody, though, guess what? He's been charged in the deaths of Valerie Mack, Jessica Taylor, Maureen Brainerd Barnes, and Sandra Castillo. Now, Heuermann has maintained his innocence and has pled not guilty to all the counts. One of Heuermann's attorneys says that his client risks being improperly convicted because of the cumulative effect of the evidence put forward by the prosecution, right? How is this not propensity evidence? Anyway, he has argued that there's a substantial disparity in the evidence in some of the deaths, which he maintains involves different time frames, killing methods, and locations of disposing of the body. Therefore, it must be a totally different person, obviously. Anyway, the dangers of having count after count, victim after victim in the same trial. If there's smoke, there's fire. That's kind of the mentality. They shouldn't be tried together on issues of having to do with the other. Anyway, the prosecutors, they haven't responded yet, but they're going to file a written response to the DNA challenge and said they would respond to the motion for separate trials. Now, Heuermann's next court date is February 18th, so it is only a few weeks away. Now, DNA test results from the hair strands at some of the crime scenes are among the key pieces of evidence prosecutors have put forward to rely upon getting their case. Anyway, the district attorneys maintain that DNA science is sound and that his office will oppose separate trials. And in their Wednesday filing, prosecutors argued that the whole genome sequencing technique utilized in the case has been widely accepted and is peer-reviewed by scientific journals, by federal regulators, paleontologists, virologists, and medical communities. The findings by the Astria Forensics, a California lab who independently corroborated the mitochondrial DNA testing methodology, has long been accepted by the New York courts, according to the prosecutors, and the whole genome sequencing enables more comprehensive collection and evaluation of DNA, and it is also widely used in scientific, medical, and forensic purposes, and it would seem there was a little question as to whether it has been accepted in the scientific community. Prosecutors also say that Huerman kept a blueprint of his alleged crime on his computer that included a series of checklists with tasks to complete before, during, and after the killings, as well as practical lessons for next time. The learning. What did we learn from this? Little debrief, I guess. Anyway, this brings up a very good issue as it relates to joinder versus propensity evidence prohibited under 404B evidence. So obviously the prosecution has a duty to bring all the cases, usually at one particular time, if they're going to prosecute an individual. You can't piecemeal these cases. It's called joinder. And there's a thing called prejudicial joinder if the prosecution knows of various cases and they don't bring them so that they can then piecemeal them together later. Well, the prosecution's filed separate cases for each one of these murders. Now they want to try them all together. Now, normally you would think, like, let's say in a drive-by shooting, if you killed 4 people, you would have a trial for those 4 people because all of those cases are inextricably intertwined, right? It was all one single event. The question gets a little more difficult, though, when you have separate incidents and all these other separate victims spread out over a greater period of time. Are they all related? Well, the prosecutor's going to say, well, we believe one person did this, Rex Huerman, and therefore we should try all these cases together because there's a common methodology that was done, and we believe in the name of judicial economy that should be the case. However, the other argument is that each defendant has a right to be tried on these charges and these charges alone, and that each case should be tried separately to avoid the prejudicial effect of, oh my gosh, this guy's got 7 murders. Oh, he must have been doing something, right? Like his attorney says, where there's smoke, there's fire. Now, the prosecutor's going to say, well, Judge, if you don't join them, guess what? Then we're going to bring them in under what we call 404B evidence. That's evidence of other wrongs, crimes, or misconduct, but that there is some reason other than propensity, which is, hey, Judge, we think he's a bad guy and he did this before, and therefore we're going to bring this in. But we have a different reason to show maybe a plan, absence of mistake, something along those lines that are permitted under 404B. Now, let me tell you from the defense perspective, ladies and gentlemen, if the prosecutor can't prove their case as it stands alone, it's probably a weak case. When you start hearing 404B evidence coming in from the prosecutor, what that really means is, hey, Judge, we know the defendant has a right to be tried on this case and this case alone, but it's kind of weak. So we'd like you to allow in what is normally not allowed in, i.e. propensity evidence, so that we can convict the guy because we think he's a bad guy, but we have a weak case. Have we mentioned that, Judge? So think of it. 404B evidence. And what happens with 404B evidence that comes in as extremely prejudicial and shouldn't come in? The cases get reversed. Bill Cosby, movie producer Weinstein, right? Mark my words, ladies and gentlemen, 404B equals weak prosecution case. Remember that. Lori Vallow, that's right. She wanted to be her own judge in her case currently pending in, Arizona, because after all, she's been through a trial in Idaho, and how tough was that, right? I mean, she got convicted of 3 counts of murder, going to spend the rest of her life in prison. Then she's got this little nuisance case down in Arizona for the death of her former husband, Charles Vallow, as well as the potential shooting of her niece's husband, right? She doesn't like her attorneys. They want to raise competency. They want to, mess with her speedy trial rights. And she says, no, I've got this. So she's filed a couple of motions. As you may recall, one of the first motions was she wanted all the information about why she was being extradited to Arizona because she had this case in Idaho and they weren't going to extradite her. And then they did. So she somehow thinks that they can't do that. Anyway, that's denied as well. Then she files a motion for speedy trial, basically saying that her speedy trial rights have been violated and therefore, as a matter of law, the matter should be dismissed. Well, guess what? Today, a judge in Arizona has denied her motion to have her cases dismissed. Shocking, isn't it? Anyway, Lori Vallow, who is already, like I said, serving multiple sentences for convictions in Idaho, is facing 2 separate charges for conspiracy to commit first-degree murder in Arizona. Now, this specific case is connected to the attempted murder of her niece's ex-husband, Brandon Boudreaux. Like I said, representing herself, Lori Vallow argued that her case should be dismissed due to not being granted a speedy trial. The judge disagreed and said, hey, there have been delays, but those delays have been justified. Consequently, the trials are expected to proceed back to back. And Lori Vallow, like I said, who was previously convicted of killing her 2 children and her most recent husband's wife, this is just icing on the cake for her, I guess. I don't know. Now she gets to play her own lawyer, and she's finding out that it is a little more difficult than she thought it was. Obviously, right? I want a trial within 6 months. Therefore, if I don't get a trial within 6 months, the case is dismissed. Or if it's declared complex, I think it's 9 months. The first thing they teach you in law school, Ms. Vallow, is although the rule is this, the general rule, there's always an exception. And I assure you, one of the things the judges always worry about is making sure that the speedy trial rights are not violated. I can tell you, I can probably count on one finger the cases that I have seen that have actually been dismissed on speedy trial grounds, because the state will oblige you, and the judge who's ultimately responsible for that is keeping close eye on speedy trial. So is the district attorney, as well the defense should be. But I'm telling you, they usually require a waiver of speedy trial for any continuance requested by the defense. And therefore, motion to dismiss denied.